Hello, BOCES staff. Welcome to a presentation on Ed Law 2D. Today we're going to talk about what the law means and also how it is going to affect our organization moving forward, especially in the technological side of our world. So Ed Law 2D was actually approved in 2015, and in summary, the law stated that school districts need to make a conscious effort to ensure the security and safety of their staff and students online. However, the law didn't really define what secure and safe means, and so in January of 2020, they further defined the law with Part 121, and that is what we're going to talk about today, is the new pieces of this regulation. There are many facets to Ed Law 2D and Part 121 regulations. There are new requirements on the cyber security and safety side, but today we're going to mainly focus on the instructional impact on students, staff, and our community. So a couple of things I'd like to point out is we have a new data privacy policy that was approved by our board this summer and is available on our website. In addition to that, there is a Parent Bill of Rights and a parent complaint procedure that is also posted on our website that outlines how parents can submit a formal complaint about any of the software utilized in our classrooms. And also, we are going to talk in depth about the third-party contracts, and also on our website, all software that is being utilized in our classrooms need to be posted to our district website. So we're going to talk about those aspects of the law throughout the presentation. So before we get into the details of the changes, we need to define some things that are throughout the presentation, and that is student data. And student data is considered any educational records that contain personal identifiable information on a student. And teacher and principal data is much looser, and it's only records that relate to APPR and confidential information. So let's further define and talk about what is students' personal identifiable data as it relates to software applications. And so you would think that some of the typical things are the student's name, student staff ID numbers, social security numbers, things of that nature, date of birth. However, there is a piece of the law that creates, it's called linking data, and that's information that would allow a reasonable person in a school community to identify that student. And also, PII includes directory information. And so directory information is anytime you use a student email, a first name, or a last name. So those two pieces that are highlighted, linking data and directory information, is really defining how we operate with the software companies that are being utilized in the classrooms. Now that we've further defined what personal identifiable information means for students, we can now discuss the third-party contracts or the agreements that we go into with our website and software companies. And so the agreement, we need to have a signed agreement in place with any of these applications that are being utilized in the classroom, and the companies need to ensure the organization that they are not disclosing any marketing or information on our students for commercial purposes. They have to have safeguards in place that meet federal and state regulations in protecting confidential information. And also, the companies need to describe how they protect our data with encryption. So those are the three big points to the third-party contracts and what the district and the companies need to become aware of. So this brings us to what is referred to as click wrap agreements, and those are actual contracts that you go into with the software companies. So this is a popular thing. We all click through to them, but it is actually a legal and binding contract. And this is where we need to have the agreements in place prior to clicking some of these buttons. So whenever you do sign up with Google, or essentially the students do that, you or the student is going into contract with this company. So we need to be much more conscious about clicking through to these click wrap agreements. And there's an example on the right of this slide where it says sign up with Google. Very convenient, very easy, and very quick. However, it's a legal and binding contract with that company. On the next slide, we also have some additional agreements that are typical with these click wraps. So before clicking through to these accounts, we need to ensure that we have a data privacy agreement in place with these companies. So a popular one is also this allow button. This is also a legal and binding contract that the students are essentially going into with the software company. And it should not be the student that's doing that. We need to do that before the students do this allow button or agree. And it is actually, if you read into these policies, defining what is being allowed to transfer between the student accounts or the adult accounts and the companies. So this brings us to applications that we have been able to secure agreements with. And a couple examples here: BrainPop, Google Classroom, all the Google Educational Suite, Google Meets, Slides, Docs, etc., Seesaw, and Nearpod. So many of these companies that we may have used for free in the past do require that we go into contract with them in their paid products to secure their personal identifiable information. So some of the things that were free that we've utilized in the past may need to be purchased. And so we need to ensure that as an organization, we hold a third-party agreement with any of the software companies that is collecting PII on our students. Next, I want to talk about some examples about accounts that are essentially created by the staff member or the teacher in the classroom. And we can still create accounts as adults. However, we need to take a look at the linking data that could be collected, and that's why I have a caution sign on this slide with some of these applications. So some examples of some popular ones that have been utilized is Kahoot, Flipgrid, and Padlet. Those are all applications that the teacher creates the account and the students join by a code, or the teacher sends a link and the students just click on the link. So the student is not actually creating an account. However, there is information collected by these applications that is linking data. And remember, several slides back, linking data is anything that you can reasonably link a student and a teacher together. And some of that linking data is considered a first name, or initials, or the student email. So I'm going to show you a couple examples of some posts that you might not intentionally collect their data, but they are logged into Google Chrome, which if they're on an iPad, they're automatically logged into Google Chrome, and it just automatically collects this information. So that's why I have a big caution sign. So with Padlet, you can see here that it collected his login information from Google Chrome. So that is an example that the student never created an account and never logged in. However, Padlet now holds that application's information, so Chrome's information, which is directory information, student email and name. Flipgrid is very similar. So I was logged into Chrome here, and so was this participant in the workshop. So it automatically collected these things. The end user or the student did not put those in there. And with Kahoot, which you may be familiar with, the students, to identify who answered what, may put in a first name. So that is a caution, because first name, last name, initials are all considered linking data. So if you're going to use some of these applications where the student doesn't create the account and the teacher does, but the student joins the application, we really need to be cautious about those and really seek an agreement in place before we utilize those as well. The third example that I want to talk about that could apply to the law is teacher-accessed sites. So lots of applications we utilize for teacher use, and they help us in the classroom. A couple examples are Screencastify, Teachers Pay Teachers, EdHelper. They are collecting the teacher's personal identifiable information only. The students don't join the application in any way. And I do have a caution sign on this one, because there is one little instance when it could apply to Ed Law and Part 121 regulations, and that is a lot of times these applications, we're looking for materials for our classroom, and it asks, do you want to link these materials to your Google Classroom? And you will get that click wrap agreement that pops up, and that's why I have a caution sign on this one. So just a plain old worksheet, you download the PDF, you can issue that to your students. However, if you click this link to Google Classroom, you have now created a data flow between that company and Google Classroom. And Google Classroom, guess what? Holds personal identifiable information of students. And therefore, that's why there's a caution. If you click link to Google Classroom, we need to secure a third-party agreement with that vendor in order to be compliant with the law. And so these applications are typically materials that we use in the classroom, and we need to be cautious about linking that information to Google Classroom. This fourth example, and the final example for today's programming, is web resources. So things that we would send a link to for students, maybe to read an article, find out more information about something. They are not collecting PII on either the teacher or the student. You are still welcome to use those resources or open resources that are available. As long as there are no accounts created or click wrap agreements, you are free to use those. They do not need approvals for prior use. So please continue utilizing those web resources. They're fabulous, they're great, and continue to use them. Finally, we cannot depart today without a phishing reminder, because cyber attacks are 90% through phishing attacks, and those are the emails that come into our inbox. And I just want you to be aware of some current ones that are happening. There are ones that look like they're from our IT department at BOCES. There are also ones that come out from the superintendent of an organization. And another popular one is information about COVID. Those are really popular attacks. And before you click on any of these or click any of the links that are within these emails, please contact the IT department if you suspect that that is not a email that is legitimate. That is the best way to protect the organization, is not clicking on these phishing attacks, because that is typically how these cyber criminals penetrate the organization and work their way through from there. To conclude this presentation, we talked about Ed Law Part 2D, Part 121 regulations, how it affects instruction as well as our parent community. We talked about students' personal identifiable information and how linking data and directory information are included in that definition. We also talked about the need to have prior approval before we use software applications in our classrooms that is collecting personal identifiable information, which includes click-wrap agreements. And finally, can't leave a cybersecurity discussion without highlighting phishing attacks. If you suspect any suspicious emails, please do not hesitate to contact the IT department and to ensure that we are operating in the safest way online as possible. Thank you.